Hello and welcome back to our video updates. It's Sade here. Today's video is going to discuss disputes over earnest money. Earnest money, of course, is the amount of money put down by a potential buyer when they make an offer on real estate and have it under contract. And it's exactly as it sounds. It's good faith amount saying that I will follow through with this contract, that I really do mean to purchase your property. So when the earnest money is put down, it's called a receipted contract. So that means the contract is effective. That's the point at which the buyer puts down the earnest money, usually paid to an escrow officer at the title company that's going to help with finalizing the transaction. Sometimes the escrow is paid to other parties if the parties are not going to go through a title company, but it's still considered an escrow officer, whoever that middleman is that's holding on to the money. The earnest money is not of any specific amount. It depends on what you're able to negotiate. Here in Texas, by industry standards, just general practice in the area, I've noticed that it's typically 1% of the contract price. So let's say you're purchasing a property that's worth $300,000 and you're the buyer. You really shouldn't be putting more than $3,000 down for the earnest money. You could negotiate even less if you're able to. If there's a lot of interest in the property, sometimes the buyer is pressured into putting down a little bit of a bigger amount in earnest money. And I'll discuss really briefly how you can protect your interest in case you need to back out of that contract, because the earnest money is supposed to go to the seller should the buyer fail to close on the transaction. So remember I said if the buyer fails. So it's not if the seller changes their mind or if the seller is not able to provide clear title, then of course that's not the buyer's fault at that point, and that is a failure on the part of the seller. So what tends to happen is when a contract doesn't finalize, for whatever reason, both sides claim that it was the other side's fault, or it was the fault of some unknown entity out there, or it was out of their power and control. Therefore, they are supposed to keep that earnest money. The reason why the disputes tend to drag on is because the contracts require both sides to sign the form called release of earnest money before the escrow officer would release it to one party or to both parties, depending on the agreement, right? So typically it's supposed to be released back to the buyer if the contract is terminated by the seller. If the contract is terminated by the buyer, usually the earnest money is released to the seller to keep it. Unless, of course, this is the exception when you have purchased an option period. The option period is the period of time where you can back out of the contract pretty much for no reason at all. Maybe you change your mind, maybe you realize your financial situation is not what you thought it was, and that period of time you're allowed to back out of the contract without additional explanations or any real cause. And the option period fee has to be paid up front and deposited by the seller before you actually have an active option period. The most common time frames are 3 days, 7 days, 10 days. You can purchase more than that if you're really good at negotiating. I suggest it should be at least 10 days to allow you time to back out of the contract without losing your earnest money. If some things don't feel right once you start getting into the contract, or if your inspection report comes back and you don't like things that you're seeing in your inspection report. So most people will do a walkthrough where they visually look at the property themselves, and then very cautious people, which you should be cautious if you're putting down 300 grand, that's not a small amount of money. So you should get an inspector to go out there really fast once you sign that contract and put down the earnest money. The inspector would go around and look at the structural issues that might be there. They will look at the infrastructure. They will look at electrical systems and things like that. So they'll give you a better overview of what the condition of the property is. If the report looks scary to you, find out more information. If it looks like you might be putting in a lot more money once you close on that property, then you could back out of that contract within your option period. And there are requirements on how you have to terminate. It has to be in writing, and it has to be done by 5 p.m. typically. So just check out the requirements and make sure you follow them to a T, because that's what tends to happen when people start fighting over earnest money. You have to get down to the technicalities and make sure every step is followed according to the terms of the contract. The other thing that I wanted to mention is that termination, it's a legal term. It's not as easy as it sounds to be able to determine who terminated the contract or whether it was terminated for cause. It's an art form in interpreting the law, interpreting the facts as they happened. And of course, each lawyer on either side would argue differently sometimes, but some of the time it's very clear who was at fault. So let me give you a couple of examples. For example, if I, as the seller, am not able to provide you clear title, the title company starts looking into the records and they find out that there are issues with the title that will not be able to be cleared, meaning that the seller may not have good title. Then I, as the buyer, if I were the buyer, I can then back out and say, I don't want to do this contract anymore. Even if it's beyond my option period, or if I never purchased any option period, then I'm still able to back out and get my earnest money back, because it's clear that that issue was with the seller. So the seller is the one that terminated in that case, even though I, as the buyer, moved first to terminate. But it was because the seller couldn't provide clear title. So the termination was for a good cause. The other example I wanted to give you is, let's say I, as a buyer, needed to get financing to be able to purchase this property. And we have that inside the contract saying, yes, you have 60 days to get your money together to be able to do the closing. And then I come back after 60 days and I still don't have my financing in place, but I get an extension from you. Well, I can only get so many extensions till you, as the seller, would have to say, no more extensions. We've already extended it to you for you once or twice, and we don't have faith that you'll be able to close on this transaction, so we would like to advertise to other people. So at that point, the seller on the surface looks like they're terminating the contract, but in reality, the buyer is the one that's causing the seller to terminate the contract. So in that case, the earnest money should stay with the seller. So when people don't sign off on that release of earnest money, the escrow officer can wait 15 days, and if the other side does not object to the release or doesn't answer at all, then the escrow officer is really supposed to release the money to the party requesting the earnest money. And this is dependent on each contract. Most of the contracts in Texas do say that inside the contracts, that a period of time, if they hear nothing, then they can release the money. If they hear an objection, then the parties have to go through mediation or court system to be able to resolve that dispute. Some of the time I've seen that the buyer was forced to terminate because the seller did not disclose important things on the seller's disclosure form. And the disclosure form is there to be able to tell people what kind of damages you've noticed while you had the property as a seller. You have to disclose what types of damages you noticed, what kind of repairs you've done, the major repairs, whether you had flood issues, things like that. So sometimes people omit information, and then it takes a while for the buyer to find out, and they've passed the option period and it's close to the closing date. And then the buyer finds out somehow, and they then want to back out of the contract. And the sellers who typically say, no, you have to complete this contract. And so there's the argument, who really is terminating? If the buyer is trying to back out, but they're backing out due to the seller's non-disclosure of important information. So that's why it's all very nuanced. The law is very nuanced. It's not always black and white, and it's not always very obvious what's going on until you dig deeper, You look at the very technical requirements in each contract. They do vary. So I'm just giving you examples in this video. So this is for educational purposes as always. What we do first, of course, is to send out a demand letter to the other side if we believe that our client had the right to the earnest money. If for some reason it's not 100% clear or both parties were at fault, then of course the party is going to agree to split the earnest money. Sometimes you're not even at fault, but you don't want to go through the stress of going through a court case, mediation, arbitration, whatever. So you might decide to take the high road and say, okay, we'll split the earnest money and then you can move on with your life and I can move on with mine. And then you can, resolve it that way. So if you do end up in court, the contracts do say that whoever loses is supposed to pay the attorney's fees and the court costs and all of that for the other side. So sometimes if you're not 100% sure that you're in the right, it's okay to negotiate a settlement. So that's my quick overview for you today. Hopefully this is helpful. Thanks for watching and I'll talk to you next week.